Hopefully everything's working. Oh, there we go. One more. Okay, that one's set. Here we go. Oh, here we are. We're live. Yay, we're live. Hello, everyone. Hello, good evening. Oh, I know, it's been forever. It's been forever since we've spoken. I know. Oh my gosh. It feels like forever over here on the tube because I missed last week. So I'm glad to be back over here tonight for our Tuesdays. Our Tuesday sessions here. Hello, hello, welcome, welcome, welcome. Glad to see everybody. Oh, the LSAT in October. Okay. Oh, I love it. All right, now the key to the LSAT, and I promise you that this is one of the best things you can do, is to take a lot of the practice tests. That's really it. That's really the key to it. It does seem like a long time. Oh, I know, I know. I know. There's just so much going on. I feel like, you know, it's already been like 2 years. It's been 2 years, everyone. Oh my goodness. Yes, yes, yes. No, no, I'm not in both, Linnell. I'm only over here. Sometimes I like to do a little pregame show where I can head over to the TikTok for just a little bit, especially if there's something that I really want to kind of talk about and tell everybody about. So I was kind of talking about the contempt piece that had been snuck into the budget bill, talking about that a little bit, but oh, listening. Hey, Sarah. Well, welcome, welcome. Of course, crocheting a hat. Oh, nice. Oh, I tell you, I tried knitting and I feel like I've got too, my grandma was like, you're just too angry. You're too angry. Sorry. You just pull the yarn too much. Oh, ran out of spoons. Oh, hun. I hear you. I hear you. Take a good break. Take a good break for sure. For sure, everybody. You got to make sure you're watching your health. No. Oh, really? No notification. Oh my gosh. Okay. How long have you been live here? Yeah, just a few minutes. Not for too long. The fancy magnifying glass. Yes. So, this is another one of my favorite pens, actually. So this is a pen. Look at that. See, it's got a little magnifier on there so you can see all the fine print in your legal documents, whatever you're signing. And then it's like a little post if you want to stand it up. So this is not sponsored. This is just some fun stuff. I'm just sharing. So I did have that one out tonight. Well, hello, welcome everyone. And again, thanks for being so flexible and working with me on my schedule here. So I have only, I'm only confirming for sure to do YouTubes on Tuesday. I don't have a confirmed schedule on TikTok. I don't have a confirmed schedule for any other days. So Tuesday is for sure my guaranteed spot. So I'm trying to start slow and see if I can maintain that and then add another day. So we'll kind of see. There's a lot of stuff going on, so we have a lot of things to go through, but I just want to make sure that I can set a schedule and stay to the schedule. And I think for the most part, it's working. Mostly. Yes, of course. Yes, oh yes, right. Okay, also looking, yes. Oh, it does, absolutely, Kristen. I think so as well. So for tonight, everyone, I thought I would start. I have two cases I want to go through. This one is the Harvard complaint that was filed regarding the international students, right? So this just happened where they said, you know, Harvard, you can no longer accept international students. Now they're trying to say it for everyone, but this one is specific to Harvard's complaint. And then, oh, thanks, Angel. And then the other one I have here is our 6th win I've not put it up on the poster yet, but this is our 6th win out of the administration lawsuits. This was a law firm here that was being targeted by an executive order, and the court came in and said, well, that's not okay at all. And some pretty stern words in here. And a motion for summary judgment was granted for the plaintiffs, which means, of course, they won. Not only that, but we have granted in part, denied in part, the dispositive motions, motion to dismiss denied, and then we have counts 8, 9, and 11 dismissed with prejudice, which again is that's pretty rare to see that. Here we have summary judgment granted to counts 1 through 7 and 10, denied as moot the other pieces. So we've got declaratory and permanent injunctive relief on the way, basically saying that the order again is unconstitutional. So this judge is not happy with this situation. So he's been pretty clear about it. Let me just bump this down a little bit here, see if we're okay with that. I had to get a new light, everyone, so my setup's just a little bit off tonight. Right. Oh, hello, John. Hello. Welcome. Good to see you. So, oh my gosh, Kristen, do you have jury duty? Seriously? Oh my gosh, you open it. You have to open it. Is it state or federal? Is it, oh my gosh, because I tell you what, those federal jury summons, man, those can last a long time. Yeah, definitely an unhappy judge. Exactly right. Exactly. Yeah, so yeah, I tell you, my spouse, I don't know what the appropriate label is, everybody. We've kind of talked about this before. I don't know, is it husband? Do we say husband? Do we say partner in crime? Is usually what we call it here. But he just today received jury duty summons for federal court. And when you're out in the middle of nowhere, you're going to have to drive to get to that federal courthouse. That's going to be a bit of a drive for you. So I feel bad, but not really. Not really bad. Usually the local cases, he would know the people involved because because he would know them through me, but at the federal level, no. So, oh my goodness. Yeah, it'll be really interesting. Hubby and wifey. Yeah, we really just don't, I don't know. That's so weird, isn't it? I suppose we could do that. Or really just refer to each other as babe. That's really it. Just like babe or hun. Or, dumbass occasionally. So, we're not really title people. Oh my gosh. So there's the update on that. Now let's go ahead and dive in, everyone. I've got, again, this is the law firm summary judgment that was just decided today. And then we do have Harvard. So let's just see. I don't know how to do a poll here, but let's see. Should we do Harvard first or the law firm? Let's just take a peek here. We'll do it just, off the cuff here. Should we do Harvard or the law firm first? Local courts. Yep. Harvard. Oh my goodness. Okay. What's going to make us the most angry? I think that they're both. I think they're equal. Harvard. Okay. Oh, Achilles. I got you. Okay, we'll do Harvard first. I'll dive in. Now, I'm not going to read the whole thing. It's 72 pages, of course. But we'll get the highlights. We'll do the intro. We'll hit the highlights and then hit the prayer at the end. Go through this one, and then we'll move over to the law firm one. Because, again, there's some interesting language over there that I think can be very, very interesting. But I think the Harvard complaint is going to be very helpful to set the tone for what's about to happen with all of the other all of the other colleges, right? Because we've got this issue of not just Harvard with student visas. We've got also other colleges. So they're the first ones that got targeted, and we'll have to see, where they go. So I think this will be helpful. Do we want a sticky note over here, everybody? I forget sometimes. I forget if we need a sticky note or not. Really, it was a mistake? Wow. I think I'd heard something about that too, but whatever. They make a lot of mistakes in this place. Okay, sticky note it is. We got it. We will sticky note this. Here we go. Here we are, and oh, John, that's so sweet. Oh, thanks, John. I appreciate that. I appreciate it. I'm working on some new stuff for the tube over here, everyone, so I'm very excited. I know I've kind of been a little MIA recently, but I'm working on some stuff. It's going to be fun. All right, so we have presidents here. President and fellows, right, of Harvard College. I've not seen any others filed quite yet when it comes to international students, but we had a very similar issue happen the first time he was in office. So not to this extent, but we certainly did have some problems. So U.S. Department of Homeland Security here, and this is the complaint that we'll be reading through. Complaint filed on the 23rd. And this has to do with students. Just put that there. I thought it was interesting, too, that one of the points that was brought up was, and I don't remember who brought it up, one of the minions, they brought it up and they said, we think all students should have a chance to go to Harvard. And by having students from other countries come here, they're taking spots for our own people in this country, which I thought was just absolutely ridiculous to put it that way. Because, part of the experience is being able to work and learn with other students. That's part of the learning process. And, they're not going to just pick a whole bunch of people that aren't, qualified to go just for funsies, Anyway, that part kind of got to me a little bit. All right, now I've got my special throat tea tonight and my special lozenges, so we should be good to go here. They say the same thing. Oh, exactly right. Yeah, and the Medicare, Medicaid situation as well. Right, pick the wrong college. Exactly. All right, so here we go. Let's dive in, everybody. So this again was filed on the 23rd. This is the second lawsuit in a couple of weeks. Harvard has, I think, maybe 4 lawsuits total going, but because they've got grants and various other things. So they have those going, but then we recently have had a couple of new ones. So this one was the most recent one filed. Hello, welcome in. Here we go. For more than 70 years, Harvard University has been certified by the federal government to enroll international students under the F-1 visa program, and it has long been designated as an exchange program sponsor to host J-1 non-immigrants. Harvard has, over this time, developed programs and degrees tailored to its international students, invested millions to recruit the most talented such students, and integrated its international students into all aspects of the Harvard community. Yesterday, the government abruptly revoked that certification without process or cause, to immediate and devastating effect for Harvard and more than 7,000 visa holders. Now, one thing that I think is worth noting, Legal Dad has a video up over on the talk, and he was talking about how, I just thought this was a really great analysis, how students come over here and learn, and that's part of what we export to the world, is the process of teaching, is this education. So many people come to the U.S. for college, for expertise, and then go back out into the world. And so this is like one of our major contributions to the world. And so having having this piece broken is just like an enormous letdown to the rest of the world of our contribution. I thought that was such a great point. This revocation is a blatant violation of the First Amendment, the Due Process Clause, and the Administrative Procedure Act. It is the latest act by the government in clear retaliation for Harvard exercising its First Amendment rights to reject the government's demands to control Harvard's governance, curriculum, and the ideology of its faculty and students. The government's actions are unlawful for other equally clear and pernicious reasons. They disregard the government's own regulations, under which Harvard should remain certified to host F1 and J1 visa holders. They depart from decades of settled practice and come without rational explanation. And they are carried out abruptly without any of the robust procedures the government has established to prevent just this type of upheaval to thousands of students' lives. With the stroke of a pen, the government has sought to erase a quarter of Harvard's student body, international students who contribute significantly to the university and its mission. Harvard's certification is essential for each of Harvard's thousands of international students to lawfully remain in this country while they complete coursework, obtain degrees, and continue critical research. Effective immediately, most of Harvard's thousands of enrolled F1 and J1 visa students and their more than 300 dependents will have little choice but to secure transfer to another school. And again, we have a problem with that because they're saying even other schools now, right? So another school or risk being rendered without lawful status in the United States. Effective immediately, Harvard can no longer sponsor F1 and J1 visa holders for its upcoming summer and fall terms, despite having admitted thousands. Effective immediately, countless academic programs, research laboratories, clinics, and courses supported by Harvard's international students have been thrown into disarray. The government's actions come just days before graduation. Without its international students, Harvard is not Harvard. And that's a really good point. Now, I'm not going to hide the ball here. We do have an injunction in place, already put into place. We have a restraining order injunction from the court almost immediately. One of the quickest, actually, that I've seen. Harvard had this filed, and the injunction came down so quick. It was just, I've not ever seen anything that quick, actually, at this level. Harvard therefore brings this action under the United States Constitution, the Administrative Procedure Act, and the equitable authority of this court to vacate, set aside, and enjoin the government's unlawful acts here. So that's our first piece. So here's our introduction here. Oh, thank you, Lex. Oh, I appreciate that so much, everybody. I am so thankful for the support. Next, for more than 70 years, Harvard has continuously hosted international students with so-called F1 visas on its campus in coordination with the government under a program currently called the Student Exchange Visitor Program, SEVP, and overseen by the U.S. Department of Homeland Security, DHS. Harvard has also long been designated as an exchange program sponsor to host J1 non-immigrants. These visa programs, which allow international students to enter the United States on non-immigrant visas to enroll at Harvard and thousands of other schools, have boosted America's academic, scientific, and economic success and its global standing. And we have a footnote here, which is a citation to SEVP certified schools, a citation. All right. Tens of thousands of international students have studied at Harvard under the F1 visa program. Additional international students and scholars have come to Harvard under the J1 visa program. These students have contributed to the university's research advancements in, here we go, immeasurable ways. They do so by, among other things, publishing pioneering scholarships, supporting scientific research, inventing groundbreaking technologies, and starting thriving businesses here in America. Building the international program that sponsors these students did not happen overnight. It has been a painstaking, decades-long project to cultivate the programs, opportunities, and personnel and reputation that allow Harvard to attract the most qualified international students. That those students, in partnership with the government, to ensure they can obtain and maintain the necessary visas to complete their course of study and integrate them into the Harvard community. Harvard's robust and thriving visa programs have inured to the benefit of Harvard's entire population and the United States. So again, I don't think it can be overemphasized how important uh, education is, and how essential that a piece of that education comes from working with and having people that are not just from your neighborhood here, right? So that's very important. Has anyone, I wanted to ask again, and do not, I I pause, I hesitate for a moment. I do not expect everyone to go to college. It's just absolutely unnecessary, in my humble opinion. But for anyone who has been in through high school or college or community college or whatever program that has studied abroad, could I just get some kind of a look to see if anyone, some of the countries that people have studied in? I'm curious to see, because I'm in an isolated area out here, and it's hard for me to gauge if people actually do go abroad to study as well. So what are we thinking? And again, if you did not go abroad or you did not go to college, I have nothing but admiration and respect for you. I'm just curious. Okay, Spain was one. I wish. Well, you never know. You still, there's lots of other opportunities. Okay, in Spain. Okay, love that. Florence, Italy. Okay, love it. Germany. Uh, oh, Germany. Okay, in high school. Oh, I love it. I love it. Wish I'd studied in Europe. It's a pretty amazing opportunity. Mexico. Okay, for farming. Well, also too, I've noticed that a lot of church groups do, uh, missions or something abroad. They go abroad to different places as well, which I think is fantastic. I mean, that's a wonderful way to be protected and have a wonderful experience too. South Korea, okay. Yes, yes, Kay, I'm with you. So, and I bring this up again because um, I I myself never thought I would have been able to study abroad. With my economic background, that wasn't even on the horizon for me. But my school, my college, university had an exchange program. And it was because of that program that it was possible for me to study abroad, to be able to pay for it, the tuition, and to live in the student village and take classes there. The only way that that happened was because there was this kind of a program in place, or else I would never have been able to do it. Ireland, Holland, Greece. Oh, wonderful, wonderful. Very specific for healthier. Oh, I love it. I love it. Right. Or the armed force. Absolutely. Absolutely. Mm-hmm. Mm-hmm. Love it, love it. Yes. So, yeah, and again, the payment, the way of doing that is incredibly expensive. Where I came from, it was like, what? That's not even, in my parameters. I went to Swansea in Wales, which is just an amazing place. I made some amazing friends, learned a lot about a lot. Um, and it was just amazing. My husband went to Australia and studied there for a semester. Most of the people that I know have been to mostly Europe, but I've been very, very lucky. My father in law, who is a professor, has gone into places like the Amazon and to the well, I'm trying to remember exactly. He's been to Egypt and um, Nigeria. He's been multiple times to Nigeria, Kazakhstan, Uzbekistan. He's been to, and Colombia, and as a professor at this university, this college, and so he was able to kind of take students in different programs around. And I mean, there's no way that this would be possible for a lot of people without being able to do it through school. So if you pull the program funding for this, those opportunities are going to vanish. And so that's really sad. Where they were in the Premier League. I didn't really pay attention to that. Sorry. I was more concerned about the pints. Oh my gosh. Oh, you're a host family. Oh, that's so cool. Oh, I love that too. I love that too. Yeah, yeah, exactly. Mm-hmm. Oh, South Africa. Yeah, yeah. Children, right? Afraid. Well, very exactly, and rightfully so, Diane. That's an absolute legitimate fear too. So I think it's just again, it's really important to note how much the globalization of the world plays an important role through education. I think, of course, all of us know that, but it just can't be overstated. All right, so back into it here. And no, I did not learn very much Welsh here. Uh, wants to think the U.S. is the. I know. I'm telling you. I tell you what, Kaya. Okay, here's my quick side story, everyone. Real quick, we'll go off roading and then we'll come back. So when I was studying in Swansea in Wales, they have a program called American Studies where you can actually major in American Studies. Of course, I was in political science, and so I was like, "Ooh, let's take an American Studies class." And so I walked over to the building where the classes were, and it was like American literature class. I can't even remember what it was about. But on my way over there, I saw a sign on the door saying that class had been canceled for another course, and the course was called Vietnam: The War America Lost. And I tell you what, that just rocked my world. I was like, what? I thought we died. There's just like, just written out here, just like my whole world is just shattered. And the war that the US lost. Like, all right. I mean, it just, you have to look around and see, there's just a very different perspective on everything. And there's no harm in knowing about it too. I think it's always good to collect as much information as possible. I know. And my parents are both vets, and so I was like, well, I'm not going to tell them that. All right, here we go. Back in it. Here we go. Didn't happen overnight. So here's number 8. I appreciate y'all going off-roading with me there for a moment, everyone. Memories. Here we go. Since the inception of the F1 visa program more than 70 years ago, Harvard and the government have worked cooperatively to advance these goals. Harvard has been continuously certified to host F1 visa holders since 1954. Under the modern program established in 2003, certified schools must comply with specified record keeping, retention, and reporting requirements and renew their F1 certification every 2 years. And since then, Harvard has complied with all applicable reporting requirements and renewed its certification without incident. For more than 70 years, the government has never threatened Harvard's certification. That's a pretty big deal. All of that changed on April 16th of 2025 when the Secretary of Homeland Security, Kristi Noem, sent Harvard's International Office, HIO, a letter, the records request, criticizing Harvard for failing to condemn anti-Semitism. The records request demanded that HIO produce wide-ranging information for each student visa holder, right? So this is where we get into that scary place when they're trying to make the lists of the people. All right, if you see a place where government's trying to make a list of the peoples, that should always give you pause. Across Harvard's 13 schools, within 10 business days, and further stated that failure to do so within the time frame provided, that is by April 30th, would be treated as a voluntary withdrawal from the F1 program and not subject to appeal. So again, you got to watch those lists that you're on. Yeah, it is terrifying. I agree. Despite the unprecedented nature of this demand, HIO immediately began collecting responsive records from the information it maintains or keeps accessible. And according to I like how they did this, right? So the federal code requires that they keep those records and that they're accessible. So they're like, well, we have everything required by law. And on April 30th, Harvard produced that information to DHS. On May 14th, Harvard also produced additional information in response to a follow-up request from DHS. Yet on May 22nd, DHS deemed Harvard's responses insufficient without explaining why or citing any regulation, with which Harvard failed to comply and revoked Harvard's SEVP certification effective immediately. The government termination of Harvard's SEVP certification is the culmination of its unprecedented and retaliatory attack on academic freedom at Harvard. And then they list out those different pieces. So let me walk you through the pieces here because I think that that's important as we set out this case. A, in the recent weeks and months, through a multi-agency task force to combat anti-Semitism, the government has conditioned Harvard's continued receipt of numerous federal benefits, including billions of dollars of federal funding, on accepting sweeping changes to Harvard's governance, admissions, hiring, and academic programs. B, the government enumerated these demands in extensive detail in an April 11th letter to Harvard's president. The government demanded, among other things, that Harvard hire a third party to audit the viewpoints of its students. Faculty and staff, depending on the results of the audit, hire and admit a critical mass of people to achieve the government's preferred level of viewpoint diversity in each department, field, or teaching unit. Refuse admission to international students hostile to American values, exclusively empower faculty supportive of the government's actions, and reduce the power of those opposed. This is some scary language here. This language is scary. Allow the government to review its faculty hires, expel or suspend specific sets of students, disband disfavored student clubs, and establish mechanisms for Harvard community members to report on one another and send those reports to the government. This is really scary stuff here. When on April 14th, Harvard refused to accede to these demands, the government's retribution was swift. Hours later, the government froze more than $2.2 billion in federal funding critical to the support of ongoing cutting-edge research at Harvard. Research with the potential to improve the health and safety of millions of Americans through better cancer treatments, model and manage the spread of infectious disease outbreaks, produce vital innovations in quantum computing and artificial intelligence, and reduce the short and long-term consequences of battlefield-related injuries, among myriad of other developments and discoveries. And we've got footnote 2 here. Harvard has challenged the government's freeze order and subsequent terminations of billions of dollars in multi-year grants to Harvard in a prior lawsuit. So this is the other lawsuit that's been filed on that specific question. The next day, on April 15th, President Trump posted on Truth Social suggesting that Harvard should lose its tax-exempt status as a not-for-profit educational institution under Section 501c3 of the IRC Code, the Internal Revenue Code, if it keeps pushing political ideological and terrorist-inspired supporting sickness. What? But Harvard is not a commercial business and does not seek investors to fund its activities and then share in their proceeds. So maintaining Section 501c3 status, which permits the university to receive tax-deductible gifts, raise capital from investors on affordable terms, and provide access to federal student aid programs, is vital to Harvard's existence as a modern research university dedicated to serving the public. So there's this threat here about the tax exemption piece. That would be enormous. The following day, the president doubled down, asserting in a post on Truth Social that Harvard has been hiring almost all woke radical left idiots and brain birds who are only capable of teaching failure to students, and that Harvard can no longer be considered even a decent place of learning, like Trump University, and it should not be considered on any list of the world's great universities or colleges. On April 16th, Secretary Noem sent her letter to HIO seeking 8 broad categories of information on every international student studying at Harvard under an F1 visa, threatening that failure to comply would be deemed a voluntary withdrawal of Harvard's SEVP certification, and warning that the withdrawal will not be subject to appeal. This demand was unprecedented, seeking information far beyond what DHS's regulations require Harvard to maintain and report, and far beyond any request Harvard has received in its more than 70 years hosting foreign students under the F1 visa program. That's pretty bad. Doughboy, I just personally, I just don't like to say those words. So yeah, some words I think are okay, but sometimes I just don't like to say those words out loud. I know, calling them a failure, I know. And these lawsuits are failing, and of course, Trump University was pulled as, awful. Accreditation didn't exist there. So it's just really, really difficult to understand. So, F, just hours later, DHS issued a press release announcing both its cancellation of two DHS grants totaling over $2.7 million to Harvard, as well as Secretary's scathing letter demanding detailed records on Harvard's foreign student visa holders' illegal and violent acts. The press release asserted that Harvard has allowed anti American, pro Hamas ideology to poison its campus and classrooms and undermine America's values. It added that DHS's demand for records encompassing thousands of student visa holders follows President Donald J. Trump's decision to freeze $2.2 billion in federal funding to Harvard University, proposing the revocation of its tax exempt status over its radical ideology. And it concluded by stating that if Harvard cannot verify it is in full compliance with its reporting requirements, the university will lose the privilege of enrolling foreign students. If I'd conditioned myself, well, no, there's just some words that are very difficult. G, despite the unprecedented nature and scope of the April 16th demand and the lack of any clear authority for most of the requests, Harvard worked diligently to collect and produce the information it is required to maintain and report under the SEVP program. On April 30th, Harvard produced responsive information falling within 8 CFR section 214.3 sub G sub 1, which is what's required under the law. Specifically, Harvard produced to DHS thousands of data points concerning its entire F1 visa student population. Then, on May 7th, DHS notified Harvard that DHS believed Harvard's initial production was incomplete, and now, invoking all of its authority under 8 CFR Part 214, asked for 4 of the 8 categories of information referenced in the initial request. This request continued to be both unprecedented and well beyond the scope of the authority invoked by DHS. But in response, Harvard again conducted a search and again produced additional responsive information. In the wake of Harvard's productions, DHS summarily revoked Harvard's SEVP certification on the basis that Harvard's responses were insufficient, but it did not explain why that was so, let alone identify any actual noncompliance with the governing regulations or follow any of the detailed processes required under the regulations prior to revoking a school's certification. DHS's revocation letter leaves no doubt that the revocation is part of DHS's campaign to coerce Harvard into surrendering its First Amendment rights. The letter declares, quote, consequences must follow to send a clear signal to Harvard and all universities that want to enjoy the privilege of enrolling foreign students that the Trump administration will enforce the law and root out the evils of anti-Americanism and anti-Semitism in society and campuses. Or put another way, because the administration perceives that members of Harvard's community have the wrong viewpoints, Harvard will be punished until it alters its viewpoints to satisfy the administration's demands. Yikes. Whew. All right. So that's really, I think, a huge piece of what's going on here. And I just have to say that it's so incredibly well written, everybody. This is just so well written. And of course, I mean, it's Harvard, so of course it's going to be well written. But, right. Mm-hmm. Yeah, hard to grasp that it's real. Yeah. I mean, again, uh, we have every generation has problems, every time period has problems, but right now it's interesting to see how one particular person is able to just kind of take uh, the credit for this particular era. Oh, I know. Oh my gosh, Mama Llama, exactly. Yep. I mean, it's just very upsetting, extremely upsetting. And I have another, I won't go through it tonight, but another suit here, American Association of University Professors versus Rubio. And this is a really interesting how this one's being put together as well, because again, we're talking about First Amendment freedom of speech rights. And with the way the language is set out here, I would have to do this one. I can only do this one over here. And this is the free speech and the Bill of Rights regarding what different people are saying on different campuses, and how you're not supposed to be punished for that. That's a fundamental liberty that you have in this country. So I've got this one. I'm waiting to see what will happen next in this case, and then I'll probably come back in and review it. All right. Yeah, exactly. Right. So next up, everyone, and I'm just going to get us started on this piece because I think it's just really well said and very powerful to show where our judges are along this route that we are all on here. So this is, again, this is a summary judgment motion granted that just came down today. So Wilmer and Cutler, Pickering, Hale, and Dorr. And Dorr, or Dorre, I don't know, Dorr probably, LLP v. Executive Office of the President. Executive Office of Presidents. Again, this was decided just today, granted today, and this is another one of our wins to go up in our wins column here. So that's pretty amazing. Yep, absolutely. All right, let me grab my tea again. All right, here we go. I will be revisiting the Harvard case because that's going to be the one leading the way. Both of the Harvard cases are the pioneers for those constitutional questions presented in each one. So I will be following those carefully through the different preliminary injunctions and appeals and such. So just as an FYI. So here we go. We've got a summary judgment granted here. Let me put that up there. And again, this is just a very powerful language by a judge here out of DC. The cornerstone of the American system of justice is an independent judiciary and an independent bar willing to tackle unpopular cases, however daunting. The founding fathers knew this! Exclamation point. That's interesting. That's like a little unicorn. You don't really see those in judicial opinions. Accordingly, they took pains to enshrine the Constitution certain rights that would serve as a foundation for that independence. Little wonder that in the nearly 250 years since the Constitution was adopted, no executive order has been issued challenging these fundamental rights. Now, however, several executive orders have been issued directly challenging these rights and that independence. Good point. Yep. One of these orders is the subject of this case. For reasons set forth below, I've concluded that this order must be struck down in its entirety as unconstitutional. Indeed, to rule otherwise would be unfaithful to the judgment and visions of the founding fathers. There's another exclamation point. What is happening here? That's really, yikes. Oh, I know VC. Oh, the reputations are just gone. Absolutely gone. All right, so factual background. WilmerHale. Wilmer, Cutler, Pickering, Hale, and Dorr is a law firm with over 2,000 employees, approximately 1,200 of whom are lawyers. The firm has 12 offices around the world. Its attorneys work a variety of different sectors, including criminal defense, patent prosecution, securities laws, and regulatory and government affairs, to name just a few. The firm takes on a wide array of clients ranging from large corporations, colleges and universities, and Native American tribes to nimble startups and individuals accused of criminal and civil wrongs. Its litigation practice has long advocated for clients and causes across the ideological spectrum. Keeping with that practice, WilmerHale has represented clients in litigation against the federal government during both Republican and Democratic administrations. Certain of WilmerHale's case and clients have drawn the ire of President Trump. The complaint highlights a few, including the firm's representation of inspectors general alleging that President Trump improperly fired them. Oh, goodness. The House of Representatives committees on Ways and Means and litigation resulting in President Trump's disclosure of his personal tax returns. Man, is he still on about the tax returns? Dang. The Joe Biden and Kamala Harris campaigns in election litigation and here, and the Democratic National Committee and state level Democratic Party organizations and lawsuits brought by the Donald Trump campaign challenging the results of the 2020 presidential election. Yikes. Let's go back because we've got a footnote here. A footnote. WilmerHale sued the Clinton administration at least 28 times, the Bush administration at least 68 times, the Obama administration at least 125 times, the first Trump administration at least 45 times, and the Biden administration at least 97 times, according to the evidence. Throughout this memorandum opinion, the cited paragraphs of their statement of material facts are undisputed, unless otherwise noted. Oh, goodness gracious. The firm's affiliation with, oopsies. Sorry, everybody, hold on. Hold on. So 1 second. Okay, here we go. I'm running through my battery packs tonight. That's if you do too many lives, your batteries don't have time to come back. All right, there we go. And we're back on. Ooh, here we go. Let's see. All right, the firm's affiliation with Robert Mueller III has also attracted the president's displeasure. After a long and distinguished career in the government, Mueller joined WilmerHale as a partner in 1993. He remained there until he rejoined the Department of Justice in 1995, where he ultimately served as the director of the Federal Bureau of Investigation from 2001 to 2013. Oh, I didn't know that he was in there for that long. That's a really long time, my goodness. Thereafter, Mueller again returned to the firm for a few years before then acting Attorney General Rod Rosenstein appointed him to serve as special counsel charged with investigating allegations of Russian interference in the 2016 presidential election. The complaint alleges that because of his role as special counsel, Mueller personally became the target of President Trump's ire. The complaint is replete with President Trump's statements on the investigation and Mueller's involvement. Here, collecting quotes from President Trump. Thugs, hit squad, national disgrace, exclamation point, hoax, witch hunt, very sick and dangerous people. After the special counsel's office issued its report on the investigation into the Russian interference in the 2016 presidential election, Mueller rejoined WilmerHale. He has since retired from the firm. I don't blame him one bit, my goodness. Executive orders. So this is the part that is so important for when I'm looking at it because we have so many executive orders. Again, I think, and I'm just turning to look at my wall here, we're like around 150. We just had a couple more added. I only add them to my wall if they've been put into the Federal Register, so there's a few waiting still in the queue. But there's a lot. There's quite a few. So here's the executive orders. During the 2024 presidential campaign, then former President Trump threatened to go after his political opponents and warned that when I win, those people that cheated will be prosecuted to the fullest extent of the law, adding, quote, please beware that this legal exposure extends to lawyers. After he won the 2024 election, Trump renewed these warnings, stating that we have a lot of law firms that we're going to be going after because they were very dishonest people. So that's a confession. President Trump followed through on these threats. On February 25th, he issued a memorandum to the heads of intelligence agencies instructing them to suspend any active security clearances held by Peter Koski and all members, partners, and employees of Covington and Burlington who assisted former special counsel Jack Smith during his time as special counsel. Jack Smith, as special counsel, had brought criminal charges against then former President Trump in 2 cases. And those cases were amazing, everybody. We're going to take a moment to just memories. Covington and Burling and Jack Smith were not President Trump's only target. Next up, Perkins Coie. On March 6th, President Trump issued an executive order entitled Addressing Risks from Perkins Coie, which instructed agencies to terminate contracts with Perkins. to require all federal contractors to disclose any business with Perkins and then review all contracts with Perkins clients, to limit official access of Perkins to federal government buildings, and to limit government officials from engaging in their official capacity with Perkins employees. The purpose section of the Perkins Coie order outlines its motivation. It accuses Perkins Coie of dishonest and dangerous activity, including its representation of failed presidential candidate Hillary Clinton in 2016 and its involvement in election law litigation. Perkins sued to block enforcement of the Perkins order. Next came a March 14th executive order targeting Paul Weiss. Now this is going to get, yikes, this is going to get a little goodness. We'll see how this goes. Executive orders targeting Paul Weiss, Rifkind, Wharton, and Garrison. Here, the Paul Weiss order substantially mirrors the Perkins order. Compare Perkins with Paul order. The background section of the Paul Weiss order explains that it is in part a response to Paul Weiss' partner Mark Pomerantz leaving the firm to join the Manhattan District Attorney's Office solely to manufacture a prosecution against President Trump. Wow. A few days later, President Trump announced that he had agreed to withdraw the Paul Weiss order following a meeting with Paul Weiss's chairman, Brad Karp. The president then rescinded the Paul Weiss order in toto. The Paul Weiss rescission order states that the firm had, among other conditions, acknowledged the wrongdoing of its former partner, Mark Pomerantz, and agreed to dedicate the equivalent of $40 million in pro bono legal services during President Trump's term in office to support causes including assisting our nation's veterans, fairness in the justice system, and combating anti-Semitism and other similar initiatives. Yikes. On March 25th, Trump issued another similar executive order, this time targeting Jenner and Block. That was our other win over on the win poster. Like a Perkins, Jenner and Block sued to enjoin enforcement of the executive order. So here's the WilmerHale order. On March 27th, only 2 days later after issuing the Jenner Block order, Trump issued the executive order at issue in this case, the WilmerHale order. The order is entitled Addressing Risks from WilmerHale and largely tracks the executive orders issued against other large law firms. See generally the order. I'm just going to call this the Wilmer order, everyone. It's just too many words. It contains 6 sections and is accompanied by a fact sheet. A fact sheet, Exhibit B, President Donald J. Trump addresses risks from Wilmer, the White House, and then the fact sheet here. Section 1, background. The background section of the order outlines the risks supposedly posed by Wilmer. It states, among other insinuations, that the firm has abused its pro bono practice to engage in activities that undermine justice and the interests of the United States, supports efforts to discriminate on the basis of race, backs the obstruction of efforts to prevent illegal aliens from committing horrific crimes and trafficking deadly drugs, and further the degradation of the quality of American elections. My goodness gracious. I know, Lex, that's what I'm saying. It further accuses Wilmer of employing lawyers who weaponize the prosecutorial power to upend the democratic process and distort justice. Nothing like the DOJ being told to not prosecute certain cases, right? Let's just clear that up. Here, Trump cites the Wilmer welcoming Mueller and his colleagues to the firm, despite their involvement in one of the most partisan investigations in American history. The background section culminates in a declaration that this type of weaponization of the justice system must not be condoned. Section 2, Security Clearance Review. This section contains 2 provisions. Section 2A instructs the heads of relevant agencies to immediately take steps consistent with applicable law to suspend any active security clearances held by individuals at Wilmer pending a review of whether such clearances are consistent with national interest. And then Section 2B orders the Office of OMB to identify all government goods, property, material, and services, including sensitive compartmented information facilities, provided for the benefit of Wilmer. The heads of relevant agencies are then to cease providing such materials and services to the firm to the extent permitted by law. All right, Section 3, contracting. Section 3 has multiple parts. I'm going to skip through Section 3 here, everyone. I can tell already I'm not going to have enough voice to get too far, so I want to hit, again, the highlights, which, in my opinion, are going to include this incredible racial discrimination claim here. All right, so let's head to Section 4, racial discrimination. Section 4 states that nothing in this order shall be construed to limit the action authorized by Section 4 of the Perkins Order. The relevant section of the Perkins Order, in turn, instructs the chair of the Equal Employment Opportunity Commission. I don't think we even have that anymore, do we? Is the EEOC still going? I know that they got rid of the person in charge of it. I'm not sure if it's been fully dismantled. Well, anyway, to review the practices of representative, large, influential, or industry-leading law firms for consistency with Title 7 of the Civil Rights Act of 1964. The provision also instructs the Attorney General to investigate large law firms who do business with federal entities for compliance with race-based and sex-based non-discrimination laws. Section 5, personnel. Section 5 contains two provisions. First, it instructs agency heads to provide guidance on limiting official access from federal government buildings to the employees of Wilmer and limiting government employees acting in their official capacity from engaging with Wilmer employees, with the cited goal of ensuring consistency with the national security and other interests of the United States. Oh my gosh, this is just so awful. Second, it states that agency officials shall refrain from hiring Wilmer employees absent a waiver from relevant agency head. Section 6, general provisions. This section contains limiting provisions. It states that nothing in the Wilmer order shall be construed to impair the authority granted by law to an executive department or agency or the head thereof, or to OMB's function relating to the budgetary, administrative, or legislative proposals. And it also mandates that the order be implemented consistent with applicable law here. And then the fact sheet accompanies the order. It largely reiterates the allegations in the background section of the order, but further characterizes Wilmer as a rogue law firm. That's like a branding moment. Like, that's the brand. that would be the law firm brand, everybody. All right, so let's kind of skip through here. So then we've got the procedural background, the legal standards, setting out how exactly the motion for summary judgment can work, because we've got multiple pieces. The Lujan v. Defenders of Wildlife case, this one in particular, I always like to pull this one out when it's cited, because this is the case that sets out whether or not you have standing to bring a lawsuit against the government. So the Lujan factors are very important. So that's another piece in there. And then we keep going forward. We've got summary judgments being asked. And then kind of explaining how the judge wants to answer, going through here. Oh, this is good. Okay, so let's read a little bit of this piece on Paul Weiss. The president's treatment of the Paul Weiss order underscores the unified nature of the order. The Paul Weiss order largely tracks the Wilmer order with a background section, similar operative provisions. When Paul Weiss struck a deal with the president, he rescinded the Paul Weiss order in full, citing the firm's remarkable change of course. Yikes, the president's treatment of the Paul Weiss order shows he intended these executive orders to stand or fall as a whole. So again, the judge is saying, do we do this section at a time or do we do it the whole thing? And the judge, spoiler, said, let's just do the whole thing. So justiciability, the judge has to show he's got jurisdiction to hear the case. So we're setting out the standing piece in here. Kowalski case is a big case to have. And then Article 3 standing. Article 3 again is the judicial branch, right? So the judiciary is established in Article 3, so it needs to make sure that there is jurisdiction for federal courts. You gotta have question involved here. So, and then moving forward, I'm just kind of skimming skimming through here. Third party standing, again, this is going to be the Lujan case situation, just to make sure that, I mean, you have to have enough of a entanglement with what's going on to have standing. You can't just be like on so far removed from the actual harm that's being done, then you're not going to meet the standards set out in Lujan. Now, ripeness means, is the case even ready yet to be answered? So that we have a full ripeness doctrine that has to be met. Mootness is the opposite, so of course it means it's no longer relevant. Political question doctrine is another one of our multi-pronged questions that we have to answer. Literally, it's called political question, and because we have to walk carefully, if there is a political question in the whole debate and whether or not it's appropriate to take up the case or not. We're just doing an overview here, everybody. And moving on to the political question, looking at the history, national security concerns, and then the merits of the case. So that's part 3. First, we've got the First Amendment. First Amendment, retaliation for protected expression, which I think that's pretty major. Retaliatory action is more than sufficient to deter a person of ordinary firmness. Oh, I agree. That's good. Count 2. So again, we're denying and we're granting. So summary judgment, they're basically saying we don't even need to have a trial. There's so much evidence in front of you, judge, you can just decide, and we believe in you. Count 2, First Amendment, viewpoint discrimination. This was huge in the Harvard case. Viewpoint discrimination is when you're kind of getting into that content element of the speech itself. So it's not the fact you're doing the speech, it's like what is actually part of the speech itself. And we have a lot of different tests that we use for that. Let me see if we've got any of the big cases here. The Volo case is kind of big, not that big of a case. Let me see if there's another big one over here. Oh, Bantam Books, that's a big one. This is a huge case regarding content or viewpoint discrimination. So that's another big one if you're interested in looking up cases regarding this issue. Moving forward here, I think those are going to be probably the biggest ones. And then he's still talking about that. Count 3, First Amendment, right to petition the government. Right, so there's 5 rights in the First Amendment, 5 distinct rights, and a lot of people forget about petitioning the government here. And we're going through saying, you know what, you messed with us, we deserve to have our day in court. Do you think they'll work against them? So much evidence they don't necessarily, well, exactly right. That's it works in favor. It's interesting. Okay, let me get my head together here for a second, everybody, because right now we are in motion for summary judgment zone for a lot of our cases. So summary judgment is what the plaintiffs ask. The plaintiffs say, here's all the evidence, you have everything that you need based off of filings. But what the defendants are doing then is they're doing a motion to dismiss, saying the same thing. We don't need a trial. You have all the information in front of you and it meets the level, the burden needed for a motion to dismiss. So the defendants are saying they have failed to state a claim upon which there can be a remedy, all right? So relief can be granted. That's the standard for a motion to dismiss. Meanwhile, the plaintiffs are saying there is just an overwhelming amount of information here that going any further is just absolutely unnecessary. So they're filing cross motions. And what we're seeing in some of these cases is that the judges are like, man, let's not even deal with the motion to dismiss. Let's call this a cross summary motion. So they're just kind of turning the defendant's dismissal into cross summary motions because then it makes it easier for them procedurally. But this is the world that we're in right now. We're in, our cases, I don't know, maybe 70% of the cases are asking for this summary judgment, saying, we don't need trial, and then also the dismissal as well. Just to kind of clear that up, that's both sides agree that trial's not really needed here, that there is just enough based off of the administrative record to be able to make a decision, either for the plaintiffs or for the defendants. So they're both asking for it to be kind of finished up. Hopefully that answers your question that you probably didn't ask. You're welcome. All right, count 4, free association. We've talked about that one before. The Bonta case. This is probably one of the biggest cases for the association doctrine here. It's the Bonta is not a great case, by the way. I didn't care for Bonta myself, but it's, it is what it is. Separation of powers, spending clause. This is a huge issue in several of the other cases where the federal funds are being frozen. Now, count 5 here, again, all these counts have been dismissed or have been summary judgmented. It had me wondering, well, everybody does. This is important here. This doctrine is called the ultra virus presidential action. And so this doctrine, we're seeing this over and over and over again. And almost all of the cases that are being filed now, probably starting late March, the cases filed against the administration are all including an ultra virus piece. And this just means it's an abuse of power is what this means. They're saying the president has abused his power as president to put these executive orders out there. And because of that, then harm is being done. So, keep your eyes open for this doctrine because this is really one of the biggest roadblocks for the administration here. The government had overwhelming evidence of gang activity. They'd asked for some. Well, true story. True story. You're not wrong. You're not wrong. All right, count 11. Wait, sorry. It's getting late, everybody. No, that's right? 11. Spending powers here. And then due process and equal protection. We've been talking about that a lot. Fifth Amendment due process, because it's a federal case, again. Judge Dugan's case. I'm not really following it very closely. I hit the highlights, but I feel like there are a lot of other creators that are doing some good work on that particular case, so I feel like it's getting covered. All right, so 5, 6, 7 here. Fifth Amendment due process. The Roman numerals are all blending together, everybody. It means it's about bedtime. Oh my gosh. All right, 8, equal protection. Let's skip to the end, everyone. We're fast forwarding. We're walking. Here we go. All right, here's the remedies. Oh my gosh. That's not too bad, going through 2 huge orders in one night. We're doing all right. All right, here we go. Here's the remedies. What are they asking for? And what can the court do? And the court is saying we're going to give summary judgments to these counts to the plaintiffs. There's violations of the First Amendment, the Fifth Amendment, and the Sixth Amendment, and the separation of powers doctrine because of that abuse of power by the president. Right, 5, 6, 7, 8. And dance. Yes, exactly. They're asking for a declaratory judgment and permanent injunctive relief. Here, the courts found that the order is unconstitutional and will issue a declaratory judgment to that effect. And then 34 down here says, while the order includes a provision, this order shall be implemented consistent with applicable law, the court has found that the order as issued is unconstitutional. Woo, that's a burn. So let's back up a little bit. This is kind of like one of the burns on the way out the door, where within the executive order, there are sentences that say, you within the compliance of the law. And there's multiple subsections, so long as it's in compliance with the law. And so what the judge here is saying, I'm not going to go piece by piece, right? This whole thing is, as issued, is unconstitutional. So even those pieces that are saying, and be in compliance with the law, because they're taken as a whole instead of in the pieces, it all needs to go. The whole kit and caboodle is out the door here. We've got enjoining the enforcement of the order. Again, we're kind of going fast forwarding because we already know the results of what happened here. So we've got that permanent injunction set out. So here is the final question, is whether the court could or should sever any sections of the order, right? So should we have any pieces of it? The order does not contain a severability clause, so it wasn't written in a way that makes it so it could be severable. Additionally, as explained in Analysis 1, the operative provisions of the order are intertwined with Section 1, and the President's treatment of the Paul Weiss order underscores the unified nature of the WilmerHale order too. And I love how this judge uses the Paul Weiss order, where they capitulated, as a justification for WilmerHale winning. I love that. I think that's like a little extra something there for them. Oh my gosh. All right, and so the entire order is tossed, and then here's the conclusion. For reasons set forth above, I find the orders unconstitutional, so the executive order's out. The court will grant in part and deny in part each party's dispositive motions. Defendant's motion to dismiss is denied, except to the extent it seeks to dismiss count 8, count 9, and count 11, which will be dismissed with prejudice. Again, very rare. WilmerHale's motion for summary judgment will be granted as to counts 1 through 7 and 10 and denied as moot, so not even relevant because of the other rulings. Counts 8, 9, and 11. The court will issue both declaratory and permanent injunctive relief. The order consistent with the above accompanies this memorandum opinion, signed by Judge Leon here. Whew. All right, we made it through. We skipped ahead a little bit, but again, this is like almost 75 pages of an order here. This is quite a bit, but I think the judge did a pretty good job of setting all the pieces up and setting out a pretty solid win and a record for appeal if needs be. Exactly right, Beth. But professional, exactly right. Do you think that they need to put an attorney in jail in order to stop these bad faith lawsuits? I think they do. I think they absolutely do. These attorneys, basically, how I see, are just they're just like spoiled children, and they won't stop until there's a negative consequence that is their currency. Now, I'm not saying put kids in jail, don't get me wrong. I'm just saying whatever accountability they've been dealt with up to this point is not serious enough for them to change their behavior. And if jail would do that, which I think it's possible it could, or they could turn in a huge publicity stunt also, if that would make it so their behavior would be changed from that negative consequence, then yeah, I think it has to happen. But yeah, more than one, absolutely, absolutely. They have to have some kind of accountability that will be significant to them. It has to be important, some kind of loss that bothers them. Like if you think about it too, in Engeron's case in New York, in the New York civil case, there were fines because it was all about the money, right? And the Florida CNN case, where Haba and Trump were both fined almost $1 million, and it's because that money was the thing. The money was the trigger in those cases for the people they were dealing with. So then they knocked it off. And the E. Jean Carroll case also, like he was defaming her like every single day. He would like leave, and then there would be the defaming and then come back in until the judge was like smacking down on the money. And that's what happened. Hope you read a book one day about this whole shit show. Oh, well, I might write a book. Prison Barbie, no, in an orange jumpsuit. Oh, yeah. Well, you never know. We might see it. Those fines didn't change their behavior. Well, I would say that the fines, the filings in the Florida case slowed down. And I'm talking again about a civil case when they were given the $1 million sanction. And also, he stopped talking about E. Jean Carroll. He stopped defaming her after like what do we have, 8, 9 contempt charges? He stopped. So it did have some effect. It did have some effect. Was it quick? No. Was it significant enough that it would be, satisfactory for the rest of us? Probably not. 11, thank you. Thank you for that. Yeah. So you think of the other cases, again, like No, you're absolutely right. It was like, whatever, we don't care. It's like King Kong with mosquitoes. But in some of those situations, especially as I said with E. Jean Carroll, where she's like, I will come back and sue you every time. So, because every single day he'd leave and be like, blah, 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 blah. And so he was sanctioned. And then I think the combo of the loss of money plus Miss Carroll saying, I will sue you for each and every single one of them, I think together, that was the 1-2 punch that got him to chill the H out on that. No stylist. Oh my gosh. Right. It will help you prove that. I would need the help too. I would need the help with that one. Oh my goodness gracious. If these DOJ lawyers are sanctioned with fines, the taxpayers pay them, right? So that's a really good question, and I'm not sure because, if you're personally your behavior itself is what's being sanctioned. So it's different than if you're found liable for something, like if you're sued for something, and it's when you're working, we've got, res fundis superior along those lines where the people that pay you would be paying the lawsuit. But if it's a personal sanction against a lawyer, I'm not sure where that money would come from. You would have liability insurance, but then you can also have insurance for ethical issues too. So I'm not sure. I'm not 100% sure, but I think it would need to come from the person or the person's insurance. Yeah, they can't. I agree. They can't take it. Isn't that judge still overseeing the Trump administration finances? Well, right. Yes. So they have the that poor judge. She's a retired judge, Barbara, I think her name was. And yeah, she's watching out for that. That case is still going, everybody. It's still going. It's going through the process, going through the system. E. Jean Carroll cases still going through the process. Everything's being appealed. Everything's been given the green lights. The Blasting Game case, all of these have been going and going and going. I think the latest appeal where they asked to dismiss the case was just in March. So they're all still going. They're all still going slowly but surely all the way through the process. So none of that has been thrown out. None of those civil lawsuits have been. Barbara Jones, that sounds right, VC. Yeah, that does sound right. So none of those have been dismissed. Again, we've got findings in the New York civil case with the Letitia James case. Then we have the criminal case. That's done, but that's on the record, right? So that's judgment is finished on the record for that. Could be Barbara Edwards. I can't remember her last name either. I feel bad for her though. And then we've got the E. Jean Carroll cases going on there. So, I mean, there's a lot of stuff going on. And then, of course, Giuliani's got his cases going. Mike Lindell's trial starting in a few days, everybody. That's exciting. Somehow that's going to be exciting. Sidney Powell's defamation trial is still ongoing. So she's still in the middle of that. And the Georgia case, quite frankly, is still open. So there's still stuff going on. The only thing in the Georgia case is that the DA has been told she cannot go forward, so that you need to have a different DA do it. But the case is still good to go. I mean, it's a state case. So anyway, all of the cases that have been all there, they're still there. They're just to the side at the moment. But they're still going. Yeah. So with that, my friends, I will go ahead and sign off for tonight for live number 3. And my Tuesdays on the YouTube are so much fun, and I really enjoy my time over here with you. So thanks for coming by, everyone. I will keep everybody posted on this case and the others going on. I will need to make a post on putting our next win up on the poster, so that's really good. What a time to be alive. Yes. Oh my goodness gracious. They should have another team in Georgia by now. Yeah, I think so too, VC, pretty soon. I think we're going to see something, and that's going to shake some stuff up too. So yes, thank you all for coming. I'm so glad you could come and hang out with me and talk about some interesting stuff that nobody else wants to talk about with me. So I really appreciate it. Take care, and I will be around, of course, next Tuesday on the tube, and I'll have some pop-up lives on TikTok. So have a good night, everybody, and take care.